Yes, thank you so much. And as you already can see from the title, we're going to talk today about the mobile ecosystem. And I want to start right with the problem that we're facing when we talk about the mobile ecosystem. And the big problem is mobile tracking. And here I just provide you now with two kind of scandals that received a lot of attention in the last years that basically showcased the persistent trading of location data of EU citizens, which of course poses a lot of privacy risks. And this is just the tip of the iceberg because mobile tracking is really persistent, not just in the US, but also in the EU. And of course, poses a lot of problems. And this is why when Apple in April 2021 introduced a new update that launched the so-called Apple Apps Tracking Transparency, it actually received a lot of positive press. And a lot of people saw it as a very positive development that finally something is been done about the problem of mobile tracking, because what the ATT in essence does is asking people if they want to be tracked or not when they open an app for the first time. However, very quickly, like this enthusiasm kind of faded because a lot of competition authorities actually entered the chat and were criticizing Apple's initiative because, in essence, this prompt that you see here is not shown when you use Apple's native apps. So Apple was accused for self-preferencing and actually also has been fined last March by the French Competition Authority for 150 million euros. And I found this development very interesting, especially with the fact that it received so much attention from competition authorities, while data protection authorities were a bit less vocal, as well as the whole data protection law community. And this is interesting because actually the General Data Protection Regulation, or in short GDPR, aims to set this baseline of protection also in the mobile ecosystem. But as you've seen before, enforcement is unfortunately lacking, and this regulatory vacuum was then actually filled by private actors, and in essence, Apple and Google. While Apple was very much more vocal and really established or framed itself as its privacy champions. And with that, it also introduced these tools such as ATT, but also other privacy enhancing technologies. But of course, this also poses some questions because now essentially a private company is setting de facto privacy standards and also redesigns the rules of tracking. So for me, it was very interesting that Data Protection Authority, as I mentioned before, did not really pay the same amount of attention to this. Because in essence, this attention should be warranted because as I argued and I looked at ATT from what this data protection law perspective, is that actually it does pose a lot of problems for data protection compliance because it essentially redefines core privacy concepts. And I argue that while ATT limits certain concerns in relation to third-party tracking, it does at the same time incentivize other practices that actually pose a lot of risks. So with this background in mind, like the two major research questions that I address in the paper are first, to what extent does ATT actually comply with the GDPR in the first place? And then to what extent EU data protection law can actually address this ability of Apple to set privacy standards. And again, I don't want to argue that data protection law is here the sole instrument that can do something about this private actor de facto standard setting, but it's just giving the perspective from EU data protection law that I think in the case of ATT thus far hasn't been received a lot of attention. But before we dive into what AT actually does, I think it's very good to first give you a bit of overview of how tracking in the mobile ecosystem actually happens in the first place and the different actors that are able to influence data processing practices within apps. And let's start with the most visible actor, the developer, because of course, the developer is kind of the main architect of an app and therefore, of course, makes a lot of decisions that impact data processing. But before the developer is actually able to make any decision, he or she has to decide if the app will actually be developed for Android or the iOS system. And once this decision has been made, the next step when actually building the app is to decide which software development kits, or in short, SDKs, to integrate. And just as a short explanation, SDKs are pre-built components that make app development way easier. And I think without them, app development would be also very costly because they can handle things like user authentication or things like crash reporting and analytics, but of course also things like advertising, and therefore also shape how data flows within an app. And finally, there is the App Store. And if an app wants to be visible and successful, it has to be distributed through one of the dominant App Store providers. And in the EU, at least, the dominant app stores are either the Apple App Store or the Google Play Store. And before publication, the app actually must pass a review process and also comply with platform-specific rules. And actually, only after that, we can enjoy our app, generate data that then might be sent off our device and end up in the hands of data brokers, which is then also, of course, problematic as we've seen in the beginning with the example of the data broker files. Now, looking at the actual mechanisms of tracking, I also want to give some very brief background information. So what you have to understand is that so-called advertising IDs, or in short, ad IDs, are very crucial in enabling tracking. And it's basically an ID that connects data points of a user. So from data that has gathered from different apps, that enables the creation of a user profile. And I think these identifiers can be very easily compared with a number plate because they enable advertisers to identify individual users, and they are also often used to actually reveal a data subject's location data to a data broker. But of course, before we can connect different data points, data actually has to leave the device. And this is usually done with software development kits that are also commonly referred to as trackers. And I already explained a bit their functions in the previous slide, because what is very interesting about SDKs is that they are, of course, very context dependent, because some SDKs, again, you need to improve the app because, for instance, they help you with crash reporting. But again, there are also SDKs whose sole purpose is actually to gather as much information about a user as possible to then send it actually to data brokers. So it really depends, I think, on the nature of the tracker to see which kind of like privacy risks are involved. And again, these two components facilitate tracking, but then when we look at tracking itself, we differentiate between first-party tracking, which is the collection of data on user activity within the company that actually owns the app that you're using. And then we have, on the other hand, third-party tracking, where a lot of user data is collected by a different company than from the company that offers the app. So I think these two differentiations will become very important. And with this kind of basis, let's dive into what actually has been changed with the 14.5 iOS update that introduced Apple's ATT. So let's just imagine we're having a phone and we're using several different apps. And all of these apps actually have access to this advertising ID that I told you before. And in the case of um, Apple devices, this ID is called IDFA. And again, these identifiers are very important because all of the data that you generate within an app can only be connected to a user profile if it's actually known that it's from like originating from the same person. And here again, the IDFA is very crucial. However, now with Apple's ATT, what has been happening is that access to this IDFA has actually been blocked by default. And the only way that an app is still able to get access to this identifier is if a user, when confronted with this screen, actually presses allow so that the app is able to still track you. So these are the basic mechanism of Apple's ATT. But what I think is actually more interesting is what ATT fails to implement and fails to recognize. And to show you that, let's just imagine we have the same situation as before. We have our phone with the IDFA. We have our 3 different apps that we're using. But now, next to the IDFA, what is very interesting is that we actually have another identifier on Apple devices, and that's the so-called ID for vendors, or in short, IDFV. And this identifier actually facilitates the tracking of user activities across apps from the same developer, so-called first-party apps. So what now is happening, let's imagine the same situation as before. We use all of these 3 apps. We gather a lot of data. The IDFA actually is able to connect these data points, but luckily we have Apple's ATT that restricts access to the IDFA. And we don't actually want the app to track us. So there's not really like a way for these apps to connect the activity to the same person. However, again, we have another identifier, the IDFV, and that actually connects the data points of the same developer. So for instance, here in the example, we have Facebook and Instagram app. These are offered by Meta, and Meta still has access to the so-called IDFV. So even if we clicked on our Ask app not to track consent screen, actually tracking still continues because Meta still has access to this other identifier that is able to create these profiles. And of course, a lot of other tracking techniques are also not affected, such as if you log in via your Meta services and then enter this authenticated environment, because of course then tracking is still facilitated and connected to your account. And also other tracking techniques such as fingerprinting, which essentially uses, for instance, certain settings on your phone that acts like an identifier, also still is able to be facilitated. So you already see, unfortunately, the effect of ATT is not necessarily that no tracking exists anymore. And I feel like this, or I found this very interesting because I think in an essence, this does reshape certain norms that we know in data protection law. And I want to illustrate this by looking at 3 different main components where I see a lot of problems with the practices of Apple. And the first one is that Apple, with this ATT framework, in essence, reshapes what tracking actually means in its ecosystem. So what you see here on the right in the screenshot is actually the definition that Apple is adopting within its ecosystem. And this definition of tracking reads as the following. Tracking refers to the act of linking user or device data collected from your app with user or device data collected from other companies' apps. And the very important component is here the other companies' apps element. Because what it essentially does is that first-party tracking is not part of this tracking definition anymore. And by focusing essentially on the actors that facilitate tracking, what tracking actually means within Apple's ecosystem is very much limited. And here again, I think it makes sense to bring in kind of the definition that we have about tracking rooted in data protection law. Because in the GDPR, we don't necessarily have an exact definition of tracking, but of very related concepts. And one of these concepts is profiling. And the crucial difference between GDPR's definition and the definition that Apple actually introduced to its ecosystem is that the GDPR doesn't really differentiate between who is facilitating the tracking. So in essence, it says that any forms of automated processing of personal data that evaluate aspects of an individual's life, such as work, performance, financial status, and so forth, can be regarded as profiling. So it doesn't really matter if this is done by a first party or by third parties. It's really about the result that matters. And I think this gives us a very well-formulated kind of normative benchmark in evaluating this definition of Apple, and see kind of like the limitations that it provides. Secondly, what I want to bring attention to is how Apple actually reshapes consent. Because also, again, there we can look into the GDPR and get a bit of guidance of how the GDPR does define consent. And it says that consent has to be freely given, specific, informed, and unambiguous. And of course, if you are not from a legal context, that might sound very worldly and maybe not that useful. But actually, when you apply it to Apple's ATT, there are important limits that I want to highlight. So actually, the consent that we are giving via this ATT prompt is not necessarily informed, because the only information that you get is what you see here on the slide, that it says, do you want to allow this app to track your activity? And this lack of a definition of tracking really raises false user expectations, because I would say that if you ask an app not to track, you really also expect that other forms of tracking would kind of be taken care of and be limited. And furthermore, because Apple is not tracking users according to this own definition it has itself, native apps also do not have to display the ATT prompt. And I think there is also where kind of like this data protection law assessment and the competition law assessment really much overlap, because this was basically the central element that has been highlighted in all the assessments by competition authorities. Because when you actually open an Apple app, you will not be presented with this consent screen, but the only way to opt out of Apple's native data processing and profiling is actually via this page that you can only access when you actually go on your iPhone's setting app, scroll down to the very end, and click on the Apple advertising screen. And what it does here is that Apple still says that it's not tracking you with its own advertising platform. Again, tracking is defined as not including first-party tracking. And you can actually opt out of this tracking by toggling this personalized ads part that you see here on the slide. So again, instead of talking about tracking, what it essentially does in its own advertising platform, it speaks about personalized ads. And that, of course, has a very different connotation than tracking. And this not only applies to Apple's native apps, but basically to any app that is facilitating first-party tracking. Because when you facilitate first-party tracking, the ATT prompt doesn't have any added value in restricting this practice. And this leads to what I argue in the paper, to the so-called rise of walled gardens. And I know walled gardens is a metaphor that has been, I think, used a lot also in relation to digital ecosystems. But I just wanted to kind of use this definition in the context of the mobile ecosystem. And in the mobile ecosystem, it basically means that users will only be able to access the content of an app in the future if it actually did identify itself by creating or logging in with an account. So what I kind of hypothesize in a way is that we will see that more and more developers have now an incentive, instead of looking for third-party data points, to actually generate a lot of first-party data. And again, the easiest way to do this is by doing this via an authenticated environment, via logins to collect this kind of data. But unfortunately, this, connecting it back to a data protection law, poses a lot of problems. Because once data has kind of entered this ecosystem, there is this internal data free-for-all mentality. And that challenges two important principles in data protection law, which is purpose limitation and transparency. And purpose limitation basically tells us that data should only be used for actually the purposes it was collected for. So just take the example of a health app. If this data has been collected for the purpose of providing you with more information about your health status, this same data should not be used actually for advertising. And the same goes with transparency. Because once you have, again, let's take the example of Facebook and Meta. Once you have a lot of different services, like in the case of Meta with Facebook, Instagram, and WhatsApp. Actually having transparency over data flows is very challenging. And I think this can be highlighted very well by the problems back in 2020, when actually Meta was changing its privacy policies and allowed for the transfer between data from Facebook users to WhatsApp users and users of Instagram, even though it actually promised before that this would never be technically possible. So these problems are very much incentivized by ATT. And again, connecting it kind of to first-party data ecosystems in general, it really reinforces a lot of privacy risks, because I here borrow this concept of so-called data power developers. So Ola Linsky, she's like a data protection law scholar, coined this term data power as a form of power that essentially rises from the control over data flows. And in her work, she argues that profiling by these data power companies is especially pronounced, and therefore especially exacerbating power asymmetries between data controllers and users. So actually, against these kind of companies or developers, data protection law should be more readily be enforced. And exactly these kind of actors, ATT doesn't really address at all. And the result is kind of highlighted by the following GIF that I always like to also show my students, because I think it really pretty much summarizes what is happening. Because Apple doesn't really check what is happening by these very powerful services that collect very much fine-grained information about us. So this, of course, now leads to kind of the second part. Now that we identified that there are substantial limitations between ATT's design and the GDPR, what can the GDPR now actually do about this kind of practice by Apple, or this de facto privacy standard setting? And before we answer this question, I think it's also kind of helpful to have a very short background information about how legal responsibility is actually shaped by the GDPR, because the GDPR applies to the processing of personal data if it's done by a controller. And in essence, it differentiates between three different kind of controllers. First, the main controller, which can be anybody in essence that determines the purposes and means of processing. And we will go in more detail what this actually means in a second. Then we have joint controllers. So here, two or more controllers jointly determine these purposes and means. And lastly, we have the processors that do data processing on the behalf of a controller. But for the discussion that we have here in relation to ATT, only controller and joint controllers are very important. So again, they determine the purposes and means of data processing. So what does this now actually mean? And in law, there has been kind of a legal test been developed. And to kind of simplify this, in essence, if the controller decides why the processing is taking place and how this processing should be done, you can pretty much be sure that we're talking about a controller here. And if we now actually go back to the mobile ecosystem, it's pretty much interesting how legal responsibility is basically shared here. Because in the beginning of this presentation, you saw that actually a lot of different stakeholders are able to influence data processing within apps. And just as a small reminder, we have the developers, we have the SDK providers. SDKs are again like these kind of small building blocks that make the creation of apps way more easy. We have the App Store providers and the operating system providers. But under the current reading in the GDPR, actually only developers are considered data controllers. That means that any obligation or basically any forms of accountability under the GDPR when we talk about apps will be directed on the developer and not necessarily these other actors that also have massive influence in how data is actually being processed. However, in the paper, I point to a very interesting development that we see at the moment, because the European Court of Justice actually has issued a judgment that accepts a very broad interpretation of controllership and can also, as I argue, be applied to Apple's ATT. And I really just very briefly want to talk about this case because it does have a lot of significance for Apple's framework. So in the so-called IAP Europe case, what has been happening is that IAB Europe, which is like an advertising business organization that kind of develops certain industry standards relating to advertising and therefore also relating to giving consent on the web, has actually been found as a joint controller together with its business users in relation to the so-called transparency and consent framework. And what this, in short, TCF does is basically a set of guidelines and technical specifications, protocols that actually enable advertising networks to acquire consent in line with the GDPR. And it was kind of challenged to what extent the role of IAB Europe in this process is. And the CGU 2 years ago actually decided that it does qualify as a joint controller, even though it actually doesn't even have access to the data that is being processed by business users using this framework. So in essence, we again have a case that pretty much is concerned with this de facto privacy standard setting. And what this example shows is that they can indeed bear GDPR responsibility. And this is highly relevant for ATT, in my opinion, because Apple, as we've seen, also pretty much designs consent architecture and also does determine the technical access to advertising IDs, in that case, the IDFA. And furthermore, it also does shape how the means of processing actually function at the operating system level. So again, even though no data protection authority has yet regarded Apple as a joint controller, with its apps over ATT, I do think that there's actually a very strong case in favor of that. But now you might ask, of course, okay, now if Apple can be regarded a joint controller, what does the GDPR actually offer us in maybe redesigning ATT or having obligations that can make ATT a bit more in line with the GDPR? And I quickly want to summarize this on this slide because in the GDPR, we actually do have some toolbox that also have a more structural component. And one of these tools is the obligation on data protection by design and default, which actually can infer certain obligations on controllers. And again, when we look at ATT, we have seen that it does restrict IDFA access by default, but it's very selective in its application because the IDFV, for instance, remains still available for first-party tracking. And again, it's very selective in applying the ATT framework because Apple's native apps and basically all other first-party apps are not subject to the ATT prompt. Because this kind of compliance is very selective, I think there is a strong case to infer additional obligations on Apple for changing the design of or the reach of the ATT prompt to, for instance, also include the cover of the IDFV. And to basically come to the end of this presentation, I just want to highlight again some of the regulatory responses that we've already seen in relation to Apple's ATT, because actually there's been happening a lot. And especially last year, we've seen some decisions by competition authorities. And here I want to really much highlight this definition or this decision that I already addressed in the beginning of the talk, because the French Competition Authority actually fined Apple for 150 million euros for abusing its dominant position. And what was pretty much central in the assessment was how ATT actually complicates consent for third-party developers. Actually, because also the French Competition Authority actually came to the conclusion by working together with the French Data Protection Authority that the ATT framework doesn't really adhere to the standards of consent that we have in the GDPR. The German Competition Authority, on the other hand, came kind of to the conclusion that ATT is a form of self-preferencing because we see that, again, Apple's native apps do not have to display the consent, the ATT consent prompt. But what I argue in this paper, to link it back to kind of the insights that I've shown you before, is that both of these decisions kind of overlook the overall incentives that Apple creates for first-party data ecosystems. Because even if, for instance, Apple's native apps would have a different consent procedure, I think there's still pretty much a lot of problems with how first-party data is being incentivized by Apple. But to come to the conclusion of this talk, let's just have a very quick wrap-up of what we've been discussing here. And the first one is that I think one of the main contributions of the paper is that Apple actually incentivizes the creation of walled gardens by incentivizing developers to collect first-party data. Furthermore, while ATT does decrease third-party tracking, it doesn't really offer a solution to tracking in general. It merely shifts tracking to other actors, while I think we still have pretty much a lot of problems with mobile tracking. And we pretty much still have a lot of very powerful actors that are not constrained at all by Apple's ATT. And to kind of connect it to these regulatory responses, again, we've seen a lot of regulatory responses by competition authorities, but I do think that data protection authorities should also be more vocal, especially when it also comes to this de facto privacy standard setting. And we've seen now, we talked about ATT in this presentation, but what Apple and Google basically do when it comes to the mobile ecosystem are a lot of other practices that I argue in my research doesn't really comply with kind of the normative benchmark that we have in data protection law, but is kind of getting away with it because this role is not really being addressed yet by authorities. So this brings me kind of to the end of the presentation. So I pretty much gave you a quick overview of what the central paper is about. But if you're interested, have a look at the full paper. It's open access and published in Computer Law and Security Review. And if you have any more questions or points of discussion, feel free to contact me, or yeah, maybe we can also have a short discussion about ATT now. So with that, I would say we can open up the floor for the discussion. And yeah, I hope that you now have a different perspective maybe on ATT as you had before.